Live from the White House is Congressman John Lewis, Democrat from Georgia, a civil rights icon whose beating at the Edmund Pettus Bridge in Selma, Alabama in 1965 helped to bring about the Voting Rights Act. Congressman, thank you for being here tonight.
Well, thank you very much, Reverend Al, for having me here tonight. I'm so pleased to be here after being in the chamber of the Supreme Court today and going over to see the statue of Rosa Parks unveiled. It is almost too much. I couldn't believe what I heard today in the chamber.
It was unbelievable, but you were sitting there as one that got beaten on that bridge and have watched what you watched. To hear voting rights referred to as a racial entitlement, I mean, how do you react to that? What were you thinking?
It was unreal, unbelievable, almost shocking for a member of the court to use certain language. I can see politicians and even members of Congress, but it is just appalling to me. It is an affront to all of what the civil rights movement stood for, what people died for, what people bled for. And those of us who marched across that bridge 48 years ago, we didn't march for some racial entitlement. We wanted to open up the political process and let all of the people come in. And it didn't matter whether they were black or white, Latino, Asian American, or Native American.
The Voting Rights Act was put before Congress after you and Reverend Hosea Williams, who represented Dr. King, were beat on that bridge in 1965 that was now known in history as Bloody Sunday. And it was to protect the rights of African Americans and then all Americans' right to vote. Section 5 meant that in districts that had the historic pattern of discrimination, any changes without pre-clearance. How is that an entitlement? I thought African Americans were citizens. For us to have the right to vote protected is some kind of entitlement program?
The right to vote is precious, almost sacred. It is the most powerful nonviolent instrument that we have in a democratic society. And if the courts come to that point where they declare this Section 5 of the Voting Rights Act unconstitutional, it would be a dagger in the heart of the democratic process. It would be a dagger in the whole process of opening up our democracy and letting all of our people come in.
One of the things that you've done every year is bring all of us, some of us that were too young to be there in 65, some that were there, and we go across that bridge with you, as we will this Sunday. And I might add, everyone from the Vice President to, I understand, Eric Cantor has said to come. You bring Republicans, Democrats, white, blacks. There were whites that marched with you in 65. Do you think that the language we heard today will sit well with the American people, no matter what their racial background and no matter what their political background? Don't most Americans agree we need the right to vote protected?
I think the great majority of the people of our country truly believe, that all of us have the right, that our right to vote, to cast an open and free vote, to be protected by the law of the land.
Now let's bring in Ryan Haygood of the NAACP Legal and Educational Fund, who helped make the argument against Shelby County's claim to the Supreme Court today. Let me ask you, Mr. Haygood, the statement I read from Ms. Greenhouse of the New York Times, that this would be an unprecedented power grab for the Supreme Court to actually interfere with the will of the people. The Congress made the Voting Rights Act, renewed it several times, including in 2006. For them to interfere with it would be unprecedented in terms of how the legal community is set up and the legal system is set up in this country. Is that correct?
That's absolutely right, Reverend Sharpton. And here's what we know. It would be even inconsistent with the Supreme Court's own precedents. Over 4 decades, 4 times, the Supreme Court has upheld Section 5 of the Voting Rights Act against constitutional challenges. Section 5 is recognized as a crowning achievement of the civil rights movement and has gone a tremendous distance in recognizing that racial discrimination in those places covered by Section 5 is of a different character than in those non-covered jurisdictions. It's more intense, it's more persistent, and it's more adaptive. And Section 5 is a strong medicine, a strong remedy to a strong type of discrimination that's persisted over time. And so the Supreme Court has recognized the progress that's been made under Section 5 of the Voting Rights Act, and the tremendous gains we've seen have been part and parcel of Section 5's important work. But what the court recognized today, even in the oral argument, is that though there's been progress, there's still persisting discrimination.
Right.
And the question, there was a very salient moment in the oral argument when Justice Breyer asked the question of the lawyer representing Alabama. He said, I think we, the court, have consensus around 2 points. One, that we've traveled a tremendous distance in seeking to eradicate discrimination in voting. But 2, we notice that voting discrimination still persists. And then, Reverend Sharpton, Justice Breyer posed this question to the Alabama lawyer. Who then can address the racial discrimination? Is it you? And the lawyer for Alabama put his hand up. No, it's not me.
Right.
And Congress in 2006 met that question, Reverend Sharpton. Congress conducted 21 hearings over 10 months, heard from 90 witnesses, both for and against reauthorizing Section 5, established a 15,000-page record. And what Congress recognized is that in the jurisdictions covered by Section 5, more than 1,000 proposed discriminatory changes were blocked in the last reauthorization
But
period.
see, I think the point is, and the congressman has been out there, we marched, we did all kinds of efforts all over this country last year.
That's right.
When they were changing voter ID laws, photo ID laws. All of a sudden, the photo ID we always had was no longer good enough. They were changing early voting days. They were changing being able to vote on Sundays. If they change Section 5 now, if they make it unconstitutional, then any of these districts all over this country, but particularly those with a pattern of discrimination, can do whatever they want, and there's no stopping it. The Attorney General or no one can stop it. This is an affront. We had a 102-year-old woman at the State of the Union address as the guest of the President of the United States who stood in line for hours because she wanted to register, because she wanted to be able to use and utilize her vote. You're telling people like that, those lines are going to be there forever and even longer. We are discouraging voters. This is absolutely unthinkable.
And Reverend Sharpton, to your point, which highlights the continuing essentiality of the Voting Rights Act and the places that it's doing some most important work, that the court has to be mindful of the real people that are protected by the real protections in the places that racial discrimination has persisted over time. Alabama, it must occur to your voters as very odd that Alabama is the place that is bringing this constitutional challenge to Section 5, and Shelby County in particular.
Yeah.
In very recent times, in 2008, of Calera, situated in Shelby County, sought to pass a discriminatory redistricting plan the Department of Justice rejected because it eliminated the city's sole African-American district by reducing the black population from 70% to 29%. The Justice Department rejected that change, and the city nevertheless held an election in which the African-American voter, a city councilman, lost his seat. Because of Section 5, the city was required to redraw its electoral boundaries and hold another election in which the African-American candidate was restored to this.
Which is an example of why we say we've come a long way, Congressman Lewis, but we still have a long way to go. No one has seen it more than you. You were the youngest member of the leading organizations 50 years ago at the March on Washington. You've seen us literally go from the back of the bus to the White House. But you are here today saying we still have a distance to go and we still need voter rights protection, Congressman Lewis.
Yes, Al, I agree. We have come a distance, we have made progress, but we're not there yet. We still have a great distance to go. When we hear the type of discussion that took place today, the question raised by one member of the court, and when you travel through many parts of America and see people standing in unmovable lines, seeing it so hard and difficult for people to cast a vote, we still need Section 5. It is the heart and soul of the Voting Rights Act of 1965. And we cannot stop now, and we will not stop now, and we will not go back.
Congressman John Lewis and Ryan Haygood, thank you for your time tonight. And let me say this.